The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the transaction of business. God save the state and this honorable court.
Good morning. Our first case is State versus Chambers, and we'll hear from the appellant.
Good morning, Your Honors. Mr. Chief Justice, Associate Justices, and may it please the Court. My name is Caden Hayes. I'm with the North Carolina Department of Justice, and I'm representing the state in this matter. At this time, Your Honor, I would like to request 5 minutes for rebuttal. Thank you. As Your Honors are aware, there are 2 questions currently pending before this Court. Whether application of NCGS 15A-1215A violated defendant's constitutional right to have a jury of 12 fully deliberate on his verdict. And second, whether the defendant waived review over the instant constitutional claim. The short answer to both, Your Honors, is that 1, application of this statute, in this case in particular, was constitutional. The Court of Appeals erred when expanding Bunning beyond its narrow holding, and further erred when rejecting and / ignoring this Court's long precedent that instructions are presumed to be followed by the jury. Second, defendant has indeed waived his constitutional challenge. Since the 2014 amendment to our Constitution, these matters should no longer be deemed automatically preserved. With that, I want to turn straight into the constitutional discussion. It wasn't but a fortnight ago that this Court reiterated not only the importance, but also the limitations of judicial review. Of course, it is this Court's responsibility to strike down laws that are unconstitutional, as this Court described in Toronto, but it should only be employed with great reluctance, resisting any temptation to intrude into the legislature's policymaking role. For that reason, in State Board of Education, this Court said that the constitutional violation must be both plain and clear. With that framework in mind, the Court of Appeals said Bunning, plainly and clearly, said that juror substitutions are always unconstitutional, no matter if there was an instruction given. This was an expansion beyond what this Court intended in Bunning. We see that in 2 distinct ways in the Bunning opinion. First and foremost, this Court limited the issue to, quote, whether an alternate juror may be substituted for a juror after deliberations have begun in a sentencing hearing. That's how it started its constitutional discussion. It did not intend, by any of the language in the opinion, to rule more broadly than that, to say that all deliberations prohibit that substitution. We can also see that in the subsequent statutory analysis this Court conducted, where it opined that the statutory scheme of the time prohibited these types of juror substitutions, not only in the sentencing phase, but also in sort of guilt innocence discussions as well, because there's only one statute, 1215, that addresses alternate jurors.
Should we have even reached the constitutional question in Bunning, or should we have simply disposed of the case on statutory grounds?
Your Honor, I think certainly the statutory scheme would have been easier to just say that and be done with it. It's tough to square this constitutional discussion. I think obviously we're here now kind of talking about what that really means. We can also look at Judge Gore and his concurrence in Watlington for this sort of kind of confusion that Bunning has created. But I think at bottom, this constitutional discussion does not plainly and clearly say that no juror may ever be substituted into a jury pool during deliberations. And that's the standard that needs to be met for this Court to strike down a statute, as it's said in Toronto and State Board of Education.
Just to follow up on what Justice Allen was saying, I could see a court, it would make sense for a court to interpret a statute and say, we don't think this statute permits this particular government action. And then after that to say, indeed, if the statute did permit this, that would be unconstitutional. In fact, I think courts do that fairly frequently as a tool to help say, this is why we think the statute means this. We'll avoid some constitutional problem if we had another interpretation. It's odd to start out and say, we think this thing is unconstitutional, this state action, and then say, oh, and by the way, we also think that it violates some state law, because that would be irrelevant at that point, wouldn't it?
I completely
And I think
agree.
that's the odd structure of the Bunning opinion, is why, if that was in fact a constitutional ruling, is it laid out in that way with so little analysis? And then there's this very detailed statutory analysis that's completely irrelevant. If the court had just held that, it would be unconstitutional to do that.
I certainly agree, Your Honor. And I think, too, if we were to say Bunning constitutionally said you can never have this substitution, then the legislature could never legislate. And so this discussion about statutory analysis is as you say, Justice Deeds, it's irrelevant. It's an unnecessary thing. So in order to give harmony to both of these sections and to give meaning to them, we should limit, or we should construe that constitutional discussion to be limited to, at most, capital sentencing hearings. And indeed, this court, as it again laid out in its issue statement on the matter, the question is whether a juror may be substituted in after or during a sentencing hearing deliberations.
But why would the Constitution forbid substitution during sentencing, but not during deliberation on guilt?
Well, Your Honor, I think capital sentencing presents a whole number of different issues that aren't present in the guilt-innocence discussion. For starters, only one juror needs to find a mitigating factor, which can dramatically change how deliberations kind of proceed. Moreover, deciding someone's life or death is a very charged and difficult discussion that touches on a number of different personal beliefs. And it would be hard, though I'm not trying to say impossible, to restart in such a situation. And fortunately, the statute at play here, 1215A's amendment, didn't extend to those types of deliberations.
So what's interesting to me about your argument from a textualist standpoint is that when you look at Article 1, Section 24, it actually doesn't mention sentencing. It mentions being convicted. But you seem to be arguing that even though the Constitution talks about being convicted, that somehow the protection is greater at sentencing than it is in deliberations on guilt or innocence.
Well, Your Honor, I fear I may have then misspoken in that I'm not advocating that there's a greater protection for capital sentencing, yes or no. What I am advocating for is that Bunning doesn't answer the question here. And Bunning, in many cases, is just irrelevant to this kind of constitutional discussion we're having here, in that we're not talking about.
I guess what I'm struggling with, I understand your point that, yes, Bunning arose in the context of capital sentencing, but what I'm looking for is some rational basis for not extending it to deliberations on guilt or innocence. I see the point that perhaps, given the principle of constitutional avoidance, the court shouldn't have reached that issue at all. But if you take Bunning at face value, I have trouble getting to where you are.
Well, Your Honor, I think this somewhat dovetails into the second point, which is this discussion about instructions and whether they can begin anew. That is, this court has long held that when a jury is given instructions, it's presumed to follow that again. This applies broadly not only to evidentiary discussions, but also these types of instructions we give to the juries, or courts give to the juries every day. And
Counsel, can you reconcile that with the assumption that I think we have to make as a matter of law, that once a jury retires, absent a specific inquiry from the trial judge about the nature of whatever deliberations have begun, that we have to assume deliberations have begun and that the jurors made some contribution? So like there seems like a tension there, and Bunning relies on Bindyke, and Bindyke states this clearly. So how do you reconcile those two?
Well, I think Bindyke is somewhat distinguishable in that there were 13 jurors in the jury room for a period of 3 to 4 minutes. Having 13 in a room violates the rule of 12 this court has consistently held out as kind of sacrosanct in terms of juries. And so we're talking about, we're not talking about a subjective inquiry when we're looking at these instructions. We're not looking at whether this specific jury did indeed restart, because that would be impossible under most understandings of juries. We don't want to invade that sanctity. But what we can do, and what this court often does in other contexts, is use some sort of objective standard. We can look at this court's decision in Snead when we're talking about a defendant's confession that was erroneously admitted, but then a curative instruction was given later. This court didn't engage in that analysis of, well, did this specific jury, would they have considered this? Well, did it really stick in their mind? No. We presumed, as the law has long held, that a jury is going to follow the instructions. And so we can't say that every single time the jury retires to the jury room, they talk for some amount of time over whatever they may be talking about. We cannot say categorically that it would be impossible for them to restart with an instruction. We cannot say that that is the extraordinary situation that was described in Franklin v. Francis, because there are many logical reasons that one would be able to restart that. Take this case, for instance. The jury retired after hearing evidence for a week and a half. They sent 2 notes, debated, drafted, and submitted them to the court in 13 minutes. And in those 13 minutes, they then came back, they retired for the day, and of course we have this substitution. I think logically it would be highly unlikely that they did engage in any substantive deliberations. Of course, to be clear, we don't need to engage in this discussion. But I think this provides a good example of times where an objective jury could be presumed to block out those 13 minutes, to block out some period of time.
I think to get there, we have to ignore some pretty clear directives from Bunning and Bindike that we don't start to make assumptions or presume, and that curative instructions aren't enough. I'm hesitant to cherry pick what in our precedent I'm dismissing as we can logic around. So I'm still looking for a way to reconcile those.
Well, certainly, again, though Bindike didn't involve an issue of substitution. There was an alternate juror in the jury room. There were 13. That invades the sanctity, that invades the idea of kind of secrecy is not the right word, but that kind of deliberative process was violated potentially. But even in Bindike, this court said that the trial courts could, going forward, ask if deliberations have begun. That seems almost tantamount to saying, or perhaps a logical step away from permitting a type of instruction such as this. Because I think at bottom, and I don't think defendant has argued against this at any point, if a jury truly did restart deliberations in a theoretical world, there would be no violation of a defendant's constitutional right. And so if we're talking about Bindike, where we're saying if the jury had not begun deliberations, then there would have been no constitutional error with that 13th member in the jury pool or in the jury room. It's a similar analysis. You have restarted deliberations, and I think it is, defendant has not shown this is the extraordinary situation where we can just toss away an instruction and say it is meaningless, not only in this situation, but in every situation, because that is what the Court of Appeals held, is that in every situation it is impossible.
So and this principle that we just can't inquire into the minds of the juries or their deliberations. Even the judge has no authority once the deliberations have begun to sort of invade that. The federal doctrine also has that same rule, right?
Yes, Your Honor. Yeah.
And the federal courts have looked at this question. It's not a violation of the United States Constitution to do what happened, what the statute requires here, what the court did in this case, right?
Certainly.
What would be the reason, sort of textually or historically, when the principle of the jury unanimity is the same in both constitutions, that we would have a different rule than the United States Constitution?
I think it boils down to, this court has long held that the term jury, as used in our Constitution, imparts specifically 12 people fully deliberating. The 12, this magic number of 12, was rejected by the U.S. Supreme Court in Williams v. Florida, and that led to now these substitutions, but also, pursuant to the Federal Rules of Criminal Procedure, a defendant can consent to less than 12 deciding his guilt.
But what's odd about that is that the number doesn't really matter. Isn't it the unanimity that's the part if there is logic in our Constitution in Bunning, it would have to be the unanimous part, not the 12, right? Because if instead of 12 it said 6 and you had 7 people in the jury room, it would be unconstitutional. So it's not the number. The number's arbitrary. It may be in fact a historical mistake, as the Supreme Court has said, but isn't it the unanimity that's the key part of the constitutional text? And we know that the United States Constitution, although that word may not appear, that's a rule in the United States Constitution as well, right?
Yes, it certainly is a rule in the United States Constitution. But our Constitution calls for unanimity as well, but unanimity gets at to whether those who are jurors all agreed upon the verdict. And at the time that they rendered the verdict, the juror who was substituted out in this matter had already left, and he was no longer would be considered as part of that discussion. You have the same 12 that ultimately rendered the verdict were the same 12 that decided the case. So I do think it maybe perhaps tinges on both, but the core right that defendant is now saying was violated was that 12 didn't completely decide his case. And the answer, in my view, is that you can simply give a thorough limiting instruction, or not limiting, but an instruction to begin anew, to caution the jury about how important this restart is. And indeed, in this case, the trial court followed the pattern instruction issued 100.40. And so, again, we're left with this. Can we really say that this is always will be the extraordinary situation where a jury categorically cannot follow an instruction, even if they walked in the jury room and for 1 second they stood in there and then they had a substitution? Can we really say that they can't forget those 2 seconds, that 1 second? Because that's what the Court of Appeals has held here.
But it seems to me you're asking us to go to the other extreme. That is to say, doesn't matter how long they've been talking to each other and how much the person who ultimately leaves might have influenced the others in their views. As long as you give her limiting instruction, it's fine to substitute. So a day of deliberations, 2 days of deliberations. It seems to me that's not what Bunning asked us to evaluate. The passage there that is elaborating the nature of respecting this constitutional right is really getting at whether or not the juror who was excused participated in the deliberations. And if they did participate, then they had a role in shaping, influencing some way or another their fellow jurors, and that in a sense, the bell can't be unrung completely. And I understand the facts here are pretty close, and I hear you that there's some point at which it's fair to say they just weren't in there long enough to even begin talking about the case. But it also seems you're saying it doesn't really matter how long they were in there, as long as they're given the instruction. We assume they followed the instruction, and therefore it's fine to substitute. And that seems to me to go much further than Bunning would allow.
I think you're on 2 points on that. One, I think there could be examples that we could envision where there could be more constitutional questions. So this is not to say that the state is necessarily asking for to just declare that it will always be constitutional in every hypothetical we can conceive of. But we do have this longstanding precedent that establishes a good test. Would an objective jury be able to, under the unique facts and circumstances of the case, be able to restart deliberations? And I think for most cases, that is going to be accurate. Relatedly, I think too, when we're engaging in this analysis, the time that they've spent in deliberations, while certainly is an important factor, I don't think it is dispositive. I think we need to give trial courts the ability to make that call on the ground and then to go through the normal appellate process in reviewing.
That's where I think this is where your argument is the weakest, because I agree with Justice Rose that it's hard to see how it can be anything other than somewhat binary. But there are plenty of you made this rhetorical point that there are plenty of examples in the law where you tell the jury through a curative instruction, just put out of your mind what you just heard. And that may be incredibly damning evidence against the defendant, but we just allow in those circumstances to have that evidence put out of the jury's mind. How do you do that? How you actually do that? I don't know, but the law says that the jurors can do that. And so it seems here we need to decide, can you do that with deliberations? Can the jury say we have to put out of our minds everything that just happened? We are a new jury now, and this group of 12 people will begin anew. And so, and in which case you can do it even if they've been deliberating for a month. Or you just can't do it because we can't. How impactful the first 5 minutes when you walk in and start delivering, that could definitely be the most impactful 5 minutes. And how are you ever going to draw that line? If we can't draw it, why would we just say, oh, we'll let the trial courts draw the line?
Well, I think, Your Honor, one, unlike in Bunning, we have a statutory directive. The General Assembly has said that this is a lawful thing. And so, certainly it would be cleaner, right, to just say when the door shuts, that's it. But the General Assembly has said, no, we think this is permissible. And so now it is, of course, upon this court to have to decide whether that truly is or not. Unfortunately, we're here, right? And relatedly, I don't think it needs to be an all or nothing type of analysis. I think that while the instruction is remarkably durable under our case law in the sense of it almost always can cure any sort of errors or protect the defendant's rights, it is not limitless. There are a couple cases here and there where this court has said, under the unique facts at play, the instruction could not have ever been enough. We see that obviously in State v. Gregory, where a prospective juror during voir dire said that she had confidential information about another suspect in the case due to her working at a law firm that represented that other individual, that it was helped the state and it would have made her biased. She said that in front of the other prospective jurors, 8 of which were later on the jury. Then, in the subsequent sentencing hearing, the defendant cast that other suspect as the real shooter. And given that, this court said, while originally the instruction would have been enough, now that this is the sole issue on there, we really don't think that that can be enough. So this is all to say, yes, jury instructions are presumed to be followed, but it's not black and white. It doesn't need to be black and white. There can be a world where we just apply the test this court has already set out.
But isn't this is to the point that Justice Driggs asked you, isn't the difference, though, that objectively everyone can see what just happened there? The judge, the counsel for the parties, we don't know what they said when the jury goes back and starts deliberating. So it's much harder to make that assessment than it would be when you can also consider how influential would that have been to me as the trial court, having heard this information and be told, forget what you just heard.
Well, I think, Your Honor, the real concern when it comes to these types of cases is what's going on in the mind of the jurors. I mean, maybe a jury could truly, in the case of Gregory, forget those interactions in voir dire. We don't know, but we do know that in that case it was too much. It was too much of a risk. To say that it categorically would be impossible to kind of shut out that period of time, I think, goes far beyond what this court has recognized, what a limiting instruction can accomplish. And so the specific words that were used in the deliberation room is not the ultimate question. The ultimate question is, can an instruction on the unique facts of each case, would it work in an objectively reasonable jury? This court has employed it time and time again, and it should do so in this matter as well.
Isn't there more that the judge could have done to ensure that this constitutional right was being protected in these circumstances, such as bringing the remaining jurors back and asking each one, can they put out of their minds anything that had already influenced them during the course of the discussion? I mean, throughout the trial, the judge is telling them, don't talk about the case, don't discuss it amongst yourselves until you retire. And we always are asking jurors, can you base your verdict only on what you hear in the courtroom and put out of your mind all other influences? It seems to me that inquiring of the jurors, do they believe they can begin deliberations anew and put out of their mind whatever they heard, as well as potentially rereading the jury instructions to all 12 of them, really emphasizing that we are starting this phase over. And I bring that up because I know other state courts have required that as part of the compliance with their state constitutional provisions.
I mean, I think, Your Honor, there's a million things a judge can do in any circumstance that maybe would be marginally better to defend some particular right. I think in this instance, maybe the trial judge could have done more, could have pulled them all aside, could have made this kind of inquiry that you're talking about, Justice Earls. But I don't think it was necessary to defend the defendant's right in this matter. The trial court gave a very thorough instruction to restart anew, and even apologized that they were going to have to do this restarting anew, and further emphasized the importance of this right, about how the defendant is entitled to this. He's entitled to have 12 and only 12 decide his guilt or innocence, starting from the same facts and deliberating the entire time together. And so, yeah, there are things that the judge could have done, but this is the record we have today, and it was sufficient in this matter to ensure the jury did truly restart. Not only in this case, but I think objectively too, we could say that this is not the extraordinary situation where no jury would be able to kind of restart deliberations anew.
I'd like to go back to your efforts to cabin Bunning. Isn't Poindexter inconsistent with that? Because doesn't Poindexter recognize that Bunning principles apply in the guilt-innocence phase of a case and not just during the sentencing phase of a capital case?
Well, Poindexter did kind of reference the Bunning holding But I think also it was, um, it involved a juror being removed from his conduct during those deliberations after they occurred in the sentencing phase. But I think also if we're to engage in this kind of almost
Is it important why the juror was removed?
in Poindexter or generally?
Generally.
Just generally, okay. So it can be. I think it's certainly a fact that the trial court can consider as to whether the defendant's rights are adequately protected. But this is, again, this is a unique kind of, not unique, but it's almost a tapestry of circumstances that the trial court can look upon to decide in each individual case.
But if you take the cases together, there wasn't misconduct in Bunning, right? And the court said, still it's unconstitutional. There was misconduct in Poindexter. The court said substitution of jurors during deliberations was unconstitutional. Why don't the two cases together stand for the proposition that regardless of the reason, the substitution of a juror during deliberations is unconstitutional?
Well, I think, Your Honor, the core issue is this instruction, right? I don't think we would be arguing that it's constitutional if there was not an instruction. I think that instruction to begin anew is important. And I think in Bunning, while it did kind of give an instruction, it was not the level of thoroughness required. And so Bunning, Poindexter, Bendyke, certainly they all stand.
Is there anything in Bunning that suggests that a more thorough instruction would have led to a different result?
I think, Your Honors, the constitutional discussion in Bunning was relatively brief. It is hard to kind of fully suss out exactly what would have been would create a different result. But what we have here is a very thorough instructions to begin anew. What we have here is a lengthy amount of precedent from this court and our Supreme Court saying that instructions are presumed to be followed except in the extraordinary situation. And not only this case is a great example of that, but more generally, we cannot say invariably that it is always going to fail. And we certainly cannot say that Bunning plainly and clearly is in violation or conflicts with the statute of 1215A. And so I know I'm running a little short on time. I just want to briefly touch on waiver very quickly, and that in 2014, the people of North Carolina amended our statute or constitutional amendment to say that no longer was a jury required to sustain a conviction. By virtue of that, the case law from this court that has said that a jury verdict, which is, improperly formed jury renders the verdict nullity, which in turn renders the judgment a nullity, that line of case law about automatic preservation should be rejected by this court today based off of that amendment, because no longer does a jury verdict need to stand, does a judgment need to stand solely on a jury verdict. The people of North Carolina said that you can waive that right, and thus it should be subject to the same preservation rules as anything else. Unless Your Honors have any further question, I'd like to reserve the remaining time for rebuttal.
Thank you, counsel.
Thank you, Your Honor.
We'll hear from the appellee.
Good morning. May it please the court. My name is Heidi Reiner. I'm here from the Office of the Appellate Defender representing Mr. Chambers. This court has heard, considered, and rejected the arguments the state has made here today on previous occasions. Nevertheless, we're here because the state does not like this court's holding in Bunning, but it's not just Bunning. It's the line of cases spanning hundreds of years bracketing that case and on which the Court of Appeals panel relied. And second, because the General Assembly attempted an improper end run around the well-established constitutional right to a jury of 12 in Article 1, Section 24. Under this court's precedent defining state constitutional right to a jury of 12, substitutions after deliberations have begun is a per se error. That's true even where the newly constituted jury is instructed to begin anew. That's true no matter how long into deliberations that substitution is made. And that's true whether the state agrees with the burden allocation the people of North Carolina have made in our state constitution. Unless and until the people of North Carolina decide to limit the right to a jury of 12 through a constitutional amendment, the state's argument should once again be rejected for the reasons this court said in Bendyke, in Bunning, in Poindexter, and in the hundreds of years of cases in which this court has called the right to a jury of 12 sacrosanct.
Would you agree with me that whatever the number is, whether it's 12 or 6 or some other number, in the United States Constitution, whatever the number of jurors is that's prescribed, you couldn't allow more than that number of jurors to go in and begin the deliberations. So in other words, if it's juries of 6 and then you just happen to have 7 people in there deliberating, that would be a constitutional problem. Would you agree with that?
Under the state constitution?
Under the United States Constitution.
I guess I don't necessarily have an opinion on that, but I think that's right. Certainly under our state constitution, that would be a problem because I think the cases taken together, as Justice Allen was talking about, Bindyke, Bunning, Poindexter, all say that the number 12, for whatever reason, is a sacrosanct number here. And I know you mentioned that maybe unanimity is really the concern, but I do think the right to a jury is sort of this big right. But I think that there are related sub-rights, not really sub-rights, but related rights that are separate from that include, under our state constitution, a jury of 12, a unanimous jury, a jury that's all instructed the same, and an impartial jury. So
I guess because the point I was trying to make is the number 12, you can easily get around the argument that, well, this wasn't a jury of 12 if you accept the notion that the state is putting forward that if you say stop these deliberations, start anew, and ensure that, again, there's only 12 people, as long as you don't have the Bindyke problem of there was some sort of mathematical overlap that, adding together how many people in the room, at some point there was more than 12, then you only had a jury of 12. So the real question is, can you start anew, swap out one of the jurors, still keep the number at 12? Or does that make it, you have to add the 2 together, and so here you had 13. And so to me, that doesn't, the magic number 12 just doesn't matter that much. You could do the same calculation if it were 6 members on a jury, as you could have in other states, or whatever the number would be.
I guess I would say that this court has said what happened in Bunning and what happened here is a jury of 13, and that's a problem. For example, in Poindexter, there were, in fact, 12 juror bodies in the deliberation room during the guilt-innocence phase, but it later came to light that one of them was not a, quote, qualified juror because of misconduct, and that rendered them a jury of 11, right? So we make these sort of calculations that are a little more abstract than the exact number of bodies in the room. I think under Bindyke and Bunning, certainly Bindyke, the alternate juror was only in the deliberation room for 3 to 4 minutes. And the opinion clearly says that that juror's presence alone, whether they said anything or not, there's no evidence that they did, their presence alone had some impact. And I think in part that's because what you were talking about earlier, the secrecy, the privacy of jury deliberations, we have no idea what's happening in that room. And I think it's also just a recognition that jurors behave differently. I think it's Bindyke has rejected the notion that you could say the first 4 minutes are somehow less important than any other 4 minutes in deliberations. And there's also things like nonverbal cues, a person's attitude. And I think we all know generally that, for example, one of the first things some juries do is take a vote, right? And that immediately steps into deliberations. And on the facts of this case, there is in fact evidence that deliberations had begun. It may not have been a long period of time, but the juror who was seeking to go to his medical appointment the next day asked his fellow jurors to stay late that evening because he seemed to indicate that they would be able to reach a verdict that night. And I will say, like, it's not as if the jurors deliberated a long time in this case, even the newly constituted jury. So the fact that it was 14 minutes or 33 or however you do the math in this case, I think is just not a factor that's at play in Bunning or Bindyke or any of these cases, the amount of time, but also on the facts of this case, it's pretty clear that they were in fact deliberating.
I think I've indicated that I see some problems with the state's attempt to limit Bunning, but would you agree that in Bunning, because the case could have been resolved on statutory grounds, the court should not have reached the constitutional question?
I think the opinion is based on constitutional grounds. Whether the court should have added the dicta about the statutory language, I think probably not. But the opinion...
Well, don't you have it sort of backwards? Aren't we supposed to avoid making constitutional rulings when we can resolve cases on statutory grounds?
It may be that the court should have done that. I guess to that I would say it didn't. But also, Bunning is not standalone. So to the extent the state is suggesting that to give the state relief in this case, all you have to do is distinguish Bunning, that's just not accurate. To give the state relief in this case, you have to, certainly Bunning is the one that's closest on the facts, and that will have to be reversed or distinguished in some serious way. But it's Bindyke, it's Poindexter, it's even Hamer in 2021, this court, in a statutory case, said that there's a group of cases, including Poindexter and Bunning, that were decided on constitutional grounds and decided that this was a per se error. And that's been the case since 1800 in Whitehurst versus Davis, when this court said there was a jury of 13, they were unanimous. We recognize that because 13 were unanimous, that necessarily means 12 were also unanimous. But there is something so sacred about that right to 12 that this verdict from 13 cannot stand.
But aren't those cases easily distinguished because here, unlike in Poindexter, there's no claim of juror misconduct, and also there's no claim that there were more than 12 people deliberating in the jury room at one time?
Well, I guess on Poindexter, I would say the jury misconduct is secondary to the constitutional violation. The violation is that there were 11 jurors that reached this verdict because the juror who engaged in the misconduct was essentially an unqualified juror. So this was a verdict from 11. And again, that's all centered on this general principle that a jury must be 12 people. And it's not necessarily as literal as there were 12 bodies in the room. It's 13 people in this case, and in Bunning, contributed to the verdict. In Poindexter, it was 11 people. But this court has said again and again, we require a jury of 12, no more and no less.
Going back to the dicta point, if you were a reader of Bunning, the opinion very clearly says that it's a violation of the statute, applicable statutes. The opinion doesn't even say it's unconstitutional. You have to infer that by a statement of the holding in Bindyke, and then the next sentence that says there also was not a unanimous jury here. And then, you can think of the reasoning and through a process of inference say, so they must have concluded it's unconstitutional. But knowing that it would be odd to do Constitution first and then statute anyway, and that there's a detailed statutory analysis concluding that it violates the statutes, isn't the more plausible reading that the constitutional analysis would be, if anything, the dicta part of the opinion?
I guess my first answer to that would be, I think starting with your last point, I think the constitutional analysis is relatively short. I wouldn't call it undetailed, but I think it's short because this principle has been clear for so long that you are required to have a jury of 12. It's the first part of the opinion, and in the last paragraph, right before it begins the statutory discussion, it says this is not the 12 jurors required to reach a valid verdict in a criminal case. That's the conclusory sentence after this long constitutional discussion about how 12 jurors are required. They don't add a conclusion sentence that says this, so this is unconstitutional. That's true. But I think any fair reading shows that the court is holding here that this is unconstitutional. And yes, they go through this statutory discussion, presumably because it was briefed and on the court's mind, and in this case was supportive of their decision. But at the end of the opinion, they do circle back to the constitutional question, when they talk about the error being one that's per se, that it's not subject to harmless analysis. They're citing Bindyke again, which is clearly a constitutional decision. So should the statutory discussion be in there? Maybe not. Should the court have decided on statutory grounds as a matter of constitutional avoidance? Maybe.
But wouldn't the statutory violation also be per se error? Because in order to engage in the statutory harmless error analysis, you would have to ask the jurors what they were thinking, and you just can't do that. So you couldn't do a statutory harmless error analysis either, right?
Right. I don't think that's conclusory, but I think the fact that it comes back to Bindyke, which is a clearly constitutional decision, is informative. But you're right, that's not dispositive.
We just issued a series of opinions that dealt with the SAFE Act recently, and there was about a half a century of case law holding that these particularly the idea that you could retroactively change a statute of limitations violated the vested rights doctrine, another constitutional protection that we have in the state constitution. And we said that that was all just dicta, and I think the exact words were that dicta upon dicta does not a precedent make. And I think in fairness, if you read a lot of those cases, it's even more explicit, the constitutional rule there, than anything that's stated in Bunning. And I'm just wondering if, sort of adhering to the reasoning of these recent decisions we've had, you just need something more than what's here in Bunning to lock us in, particularly to a rule that would interpret the text of our state constitution differently than the federal constitution when the language is almost identical and we know the meaning of both is supposed to be identical.
I guess if I could start with your last point, I would respectfully disagree that the language is identical. I think that Article 1, Section 24, like many things in the state constitution, as this court discussed in quorum, are more specific and more protective of individual rights. This court's analysis of
In
Article
what
1...
way, I'm just curious, I'm not quibbling with you, but in what way textually do you see the greater protection?
Not necessarily greater protection, but I think it's interpreted differently, I guess, because this court's language discussing Article 124 has never been tied to the federal constitution, and that's been true since this language that differs not significantly, but in part, and is more specific and limited than the Sixth Amendment. This court has always discussed it as a state constitutional right. It's been a separate, independent right. It's in our Declaration of Rights, which, based on the structure of the Constitution, is a more important right than others later discussed in the Constitution. So
I guess your best point about that would be the 12 number, right, which is not in the Sixth Amendment.
Right.
That's actually not in the text of
it's not in the
the
text
Constitution either, but it's
right.
in our jurisprudence. I mean, we certainly would be overturning precedent if we said you could have jurors of 6 in criminal cases in North Carolina.
That's right. The juror of 12.
But you could do that in federal.
You can do that in federal. And I will note that the federal courts have been allowing differences in the number of jury of 12 and allowing mid-jury substitution since, I think, 1932. So it's not as if that's a new development. That's something that was true when this court decided Bindeck. That's something that was true when this court decided Bunning. That's something that was true when this court decided Poindexter. And those, to be clear, Bunning and Poindexter are unanimous opinions of this court. And when you're thinking about overturning a ton of cases and abandoning stare decisis in this way, I think one of the considerations is whether the rule has been workable. The state talked a little bit about creating this sort of fuzzy rule as opposed to the bright line rule, and I'll note that there are a few of these cases in front of both the Court of Appeals and this court now, and that's only a function of the General Assembly enacting this statute that clearly violates our precedent, this court's precedent, because in the many decades or centuries in which the rule was once the case goes to the jury for deliberation, the alternates are excused, it's a bright line rule. It's clear. We know what happens. You start with the same 12 jurors and you end with the same 12 jurors. The workability problems have only been introduced by this statute. So to abandon that bright line rule, I don't think makes sense. And in this case, we don't know how it affected the outcome, but I know there's at least one other case pending in front of this court, State versus Thomas, where the jury had indicated that it was hung. The judge didn't inquire into the breakdown of numbers or obviously which jurors thought which way, but then a juror was substituted after that. So you can imagine a situation in which the judge, by substituting a jury mid-deliberation, has wholly changed the outcome of a case. And I think that that's a slippery slope that this court really needs to think about when you're thinking about the importance and the value that this court has said the right to a jury of 12 enshrined in our Constitution, specifically under Article 1, Section 24, what it means here.
I know for your client, setting aside, any new trial would be acceptable, but putting that aside and thinking about future cases, to the question that Justice Earls asked, do you think there could be an instruction that would cure this problem that was perhaps not given with respect to your client's case, but that could be given in future cases that could sort of harmonize Bunning with what you can do in federal court, for example?
I don't think under this court's constitutional precedent that would solve the problem. I can imagine a world in which the General Assembly went through the appropriate process and got a constitutional amendment on this issue, and then the General Assembly enacted a statute that then required those statutory extra instructions or inquiries or whatever it may be. But I think on this court's current precedent, that's not going to solve the problem. This is still a verdict from a jury of 13, 11 jurors who participated fully and 2 who anticipated partially, and this court has rejected that again and again. Just to talk a little bit about the policy arguments the state has mentioned in its briefing, I would just say that those don't really have a place in this forum because the Constitution reflects the burden allocation and the balancing that the people have already made. And while the General Assembly can certainly pass laws, it can't do so in contravention of pre-existing precedent from this court. The proper mechanism, as we've mentioned, is a constitutional amendment. As the General Assembly well knows and has demonstrated in the past, for example, when it passed the amendment allowing non-capital defendants to waive jury trials. I will note, just in regard to the waiver argument, that the official commentary to that amendment notes that amendment didn't necessarily affect the right to a jury of 12 or to the right to a unanimous verdict, that those things were considered as changes the General Assembly might make and rejected, recognizing that they would require a constitutional amendment themselves. Here, the General Assembly simply took a shortcut and passed a statute that violated constitutional decisions from this court. And if this court allows that type of shortcut, it's a dangerous precedent and essentially an amendment to the Constitution that the people have not voted on. If there are no other questions for me, I'll just close by noting that, as this court said last week in State versus Tirado, the people speak through the express language of their Constitution, and only the people can amend it. The General Assembly cannot exceed the express limits placed on it by the constitutional text. And when a legislative act goes beyond that, like it did with the passage of General Statute 15A 1215, the judiciary must use its constitutional power of judicial review to strike it down. The unanimous panel below recognized this, noting that where a statute conflicts with the Constitution, we must follow the Constitution, and this statute plainly does. For those reasons and those in the briefs, I'd ask that you affirm the unanimous decision of the Court of Appeals granting Mr. Chambers a new trial.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. I only have a couple of brief points here I want to hit on. At the top, the question is the violation plain and clear? Is Bunning plainly and clearly reject this type of substitution, not only in this matter, but also in all matters? And as shown in this analysis and discussion we've had, Justice Allen, you've had a number of questions about that, as have you, Justice Dietz. Can we really say it's plain and clear that it violates or all mid-deliberation substitutions inherently violate the Constitution under Bunning? And that cannot be the case. There's questions about, of course, if Bunning's constitutional discussion is even binding or much less dicta, and renders a number of other additional questions on top of that.
Can I just say, that I know your time is short, but the argument here is that the precedent is beyond just Bunning, and we've mentioned all the other cases that relate and apply as well. So it seems to me there's a whole series of cases that have assumed that you can't do this constitutionally.
Well, there's three cases that have hit on this, right, from this court. Ben Dyke, or there's a number, but Ben Dyke, Poindexter, and Bunning have been the three we've been talking the most about. But Bunning is the only one where there was an instruction to begin anew, and that's a critical feature of this substitution here, and brings us into the realm of the presumption that juries follow instructions, because after all, if there truly was a restart in any hypothetical case, then there was only 12 that decided the defendant's guilt. And thus there was no violation of the defendant's right. There was no 13th juror, there was no 11th juror, there was 12. And I want to also then get to this kind of policy discussion. The legislature reviewed the case law and, of course, reviewed the statutes and determined that it was best policy to enact some sort of protection against some mistrial, waste of judicial resources. I know I spent more time in the briefing to discuss that. This policy decision was the legislature's to make, given that we didn't have a clear and plain ruling that such substitutions would always violate the Constitution, even with instructions to begin anew. Thus, the General Assembly adopted a reasoned policy, a reasoned statute. You must instruct to begin anew. The School of Government then issued a limiting instruction that thoroughly recounted this, and this court should therefore uphold it today. Quickly on waiver, I just want to briefly point out My colleague references the commentary to 15A 1215. That commentary derives originally from the 1977 version of the statute. It wasn't part of the amendment that was adopted. Or sorry, under 1201, the jury waiver. That wasn't part of the discussion about the subsequent amendment, and of course doesn't envision the 2014 amendment to the state constitution. And thus, for the reasons outlined in the state's brief, unless your honors have any further questions, the state respectfully asks this court reverse the Court of Appeals below and remand for consideration of defendants' remaining claims. Thank you, Your Honors.
Thank you. Thank you to both. Mr. Clerk.
All right. Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state